Have you ever heard of the Boston Tea Party? Ye old looting. You know, I'm a British guy and I'm just gonna go loot some artifacts. We call that curating a museum. Hi, my name's Leeja. I'm a real-life lawyer and I'm on a mission to demystify the law and how it affects your everyday life. Today I want to talk to you about curfews. This summer has been the summer of protests here in my neck of the woods in Minneapolis after the death of George Floyd, and next door in Kenosha, Wisconsin after the shooting of Jacob Blake. Protests have been everywhere. They have sometimes turned into riots, and that has spurred cities to enact curfews to try to curb the violence and unrest. This has led to a number of questions about whether curfews are even constitutional under the First Amendment and the racist history of the use of curfews in the United States. I want to talk about that with you today. Before we get started, I do want to let you know that I am a lawyer, but I am not your lawyer. Nothing that I say should be construed as legal advice, and you should always seek the advice of a licensed attorney if you have any legal questions. Please be sure to hit the like button if you find this video entertaining or informational, and subscribe if you want to hear more from me. Let's go. A quick content warning before we get started. Here I am talking about protesting, rioting, looting, all in the wake of the shooting of unarmed black men mostly, and the history of that protesting and the use of curfews against specifically black people. So there will be a lot of talk of a history of racism and police brutality in this country. Alright, so why am I even talking about curfews? Well, there have been a rise in the use of curfews across the country from LA to Minneapolis this summer due to the growing unrest from the murders of black and brown people at the hands of police. But this isn't the first time, obviously, that protests and riots have been used as a means of communicating with the people in power the amount of anger and unrest that's coming from the people who are being governed. People are angry, people are feeling trapped, and the most obvious way to vent that frustration and to communicate that frustration is to get out in the streets and yell and scream and sometimes light shit on fire. Frankly, it's an understandable response to centuries of oppression. Not all of the fires and looting are being done by protesters. A number of sources claim that people from outside are coming in and using the unrest as a means to distract from their own looting and destruction that they want to do separate from the cause. But this rhetoric around looting and how it's bad and how it makes the BLM movement look bad is rooted in some pretty racist history. It also completely misses the point as to why people are rioting in the first place. And looting is used as an excuse to create curfews, which then lead to greater suppression of black and brown people and give police more of a reason to go in and arrest people in the middle of riots. This summer is, of course, in a lot of ways not unprecedented when it comes to protesting and looting and rioting over the death of black and brown people at the hands of police or otherwise. And rioting, picketing, protesting, and looting have a long history in our country. For starters, have you ever heard of the Boston Tea Party? That's like quintessential American looting. You're mad, you get on the boat, you take their tea, and you throw it overboard. Ye old looting. Interestingly, according to my research, the word loot came from the Hindu word loot, spelled L-U-T, and it was originally used to refer to the things that British colonizers did, like, you know, looting artifacts. However, it was used kind of nonchalantly and not as a criticism at first. You know, I'm a British guy and I'm just gonna go loot some artifacts, you know. Apparently guys are just writing in their diaries, hey, I'm looting today. Then in time, looting began to take on a more negative tone, and as the connotation became more negative, it started being applied not to the people in power, but instead to suppressed populations. For example, by the time colonizers made it over to North America, their actions against Native American peoples were rarely considered looting. And if you read a history book nowadays, you would probably never see the word looting when talking about colonizers coming in and taking Native American artifacts, for example. We call that curating a museum. Protesting continued to be used in United States history, including by the women's rights movement to get the vote and by the civil rights movement in the 60s, which also used violence in certain situations as a means of communicating discontent. The Stonewall riots in 1969 were a huge impetus towards the gay rights movement, and they were indeed a riot. This was not a peaceful sit-in, people. And there's a popular notion in our culture today that the civil rights movement was this movement of hippies peacefully sitting in college campuses and at cafes, but there was violence then too. A more recent example of the racial dynamics in the perception of looting made headlines in 2005. After Hurricane Katrina, there were two separate news articles that were published. One had a photo of a black man walking away from a convenience store, and it said something along the lines of "man leaving convenience store after looting it." But during the same news cycle, a different story with a similar photo on top said "couple walks away from grocery store after finding soda and baby diapers." The only difference between the two photos: The man in the first one was black and the couple was not. Both stories were published on Yahoo News very close to each other, and readers freaked out. Frankly, it's kind of lucky that they were published so close together, because otherwise people probably would not have noticed. It's so deeply rooted into our subconscious to assume that black people are looting and white people are taking what they need peacefully, that few people would have probably even noticed the racial difference between the two photos. So rioting, protesting, looting, it's written into our DNA as a country, and it's often a more effective means of communicating your anger and frustration against a system that doesn't work for you, as opposed to writing letters to your congressperson or voting. Those feel less direct. Getting in the streets and yelling is one of the only ways in American history that we've found to really push for change in this country. So people are mad, people are out on the streets, and yes, some people are looting. In this video, I'm not really interested in getting into the moral rectitude of whether or not to loot. I am saying as a human being, I'm capable of empathizing with why someone might want to. Alright, so along with rioting and protesting, curfews have been used for a long time as a means of curbing unrest, and they of course have a racist history too. So one of the most common uses of curfews in the mid-20th century was during the Jim Crow era. There were these things called sundown towns, where they were literal towns wherein people of color could not enter after dark. These were legally passed ordinances that barred people of color from entering the town after sundown, and they often posted pretty horrifying signs saying, "Don't let the sun go down on you in our town." These sundown towns were profiled in the Green Book, which if you haven't heard of it, it was a book that was used in the mid-20th century by black travelers as a means of navigating an entire country that had a patchwork of extremely racist laws that were hard to predict. So the Green Book listed these sundown towns as a means of warning black motorists of where they can and can't go after dark. One of the earliest uses of curfews as a means of quelling unrest was in 1943 during the Harlem riots, which were sparked after the shooting death by police of a black soldier. In the 1960s, curfews became a popular means of quelling unrest in Philadelphia and Rochester, New York in 1964, and during the Watts riots of 1965 in Los Angeles. They were also used in Los Angeles in 1992 in the riots following the police beating of Rodney King. And curfews have obviously been used well into the 21st century, as we saw last week in Minneapolis and in Kenosha, Wisconsin, but also earlier in the 21st century in 2014, Ferguson, Missouri was put under curfew after the death of Michael Brown, an 18-year-old who died at the hands of police. So of course, in the face of riots, authorities are trying to impose order, and one of the ways that they do that is through curfews. These curfews instead just create more tension and resistance between the two communities, police and protesters, and often just increase the chaos. Curfews are often accompanied by the deployment of police and troops into an area that's already seeing unrest and distrust of police and authorities. Stories and images of chaos and unrest often lead to pressure for people in authority to create order and create these blanket curfews, even if only a small portion of the protesters are the ones who are actually doing the looting and the rioting. The curfews also give police officers new justification to arrest more black and brown people who are out on the streets past curfew, and have led to greater mass incarceration of black citizens. Despite almost 100 years of the use of curfews as a means to quell unrest, there are actually very few studies into how effective these curfews actually are. And this law and order mentality is not just a Republican stance. In the 1990s, Clinton used the term super predators to describe youth that may or may not be involved in gangs, and to use this as an excuse to increase police presence in black and brown neighborhoods. This also led to the creation of blanket curfews for youth in the areas that were experiencing the highest levels of gang violence. This was all part of Clinton's tough on crime stance. All that these laws and curfews really did, though, was disproportionately criminalize low-income black and brown youth who were outside after dark in low-income areas, while they were trying to use public space. So when you combine all these factors, the fact that protesting and rioting are woven into the United States history and that it's part of the creation of our country, and then you add that to the fact that these rights that a lot of Americans consider to be fundamental are being curbed by the use of curfews, when you make a blanket proclamation that no one can leave their house after a certain hour, even for First Amendment activities like protesting in public space, is that even legal? Is that constitutional? And what have courts said about that? Is there a valid First Amendment argument that you could make against the use of curfews in the United States? So the Supreme Court has never ruled on the legality of curfews. However, it has ruled on the legality of similar types of restrictions on free speech. The Supreme Court case US v. Grace pretty succinctly sums up what the Supreme Court analyzes when looking at curbs on free speech like this. And that case said, public spaces historically associated with the free exercise of expressive activities such as streets, sidewalks, and parks are considered without more to be public forums. In such places, the government's ability to permissibly restrict expressive conduct is very limited. The government may enforce reasonable time, place, and manner regulations as long as the restrictions are content neutral, are narrowly tailored to serve a significant government interest, and leave open ample alternative channels of communication. Additional restrictions such as an absolute prohibition on a particular type of expression will be upheld only if narrowly drawn to accomplish a compelling governmental interest. So what does this mean in words that are a little bit more comprehensible? Well, in a public space, so that's a street or a sidewalk, places that are typically held open to the public, the government can restrict speech if the restriction is 1. Content neutral, meaning that it's not restricting a specific group of people or type of speech or idea from being communicated. So for example, if a curfew said no one who supports Black Lives Matter can go out after 8 p.m., that would be a content specific restriction, and that would be per se unconstitutional basically. However, in this situation, we're talking only about content neutral restrictions. That is a blanket restriction on all types of speech. So the government can restrict speech if it's content neutral, if the restriction is a reasonable restriction on the time, place, and manner of that speech. Keyword here being reasonable. It can't be unduly burdensome or over restrictive. And it leaves open other channels of communication. So for example, a city can bar protesters from protesting on the sidewalk in front of a government building, even though a sidewalk is considered a public forum, so long as, say, there's a park across the street where they could be doing their protests instead. And finally, the law has to be narrowly tailored to achieve a stated government interest, meaning that it can't be an overbroad blanket law that unduly restricts so much free speech that it becomes a completely overbroad restriction on more speech than is necessary to achieve this governmental purpose. In the case of curfews for rioting, the governmental purpose is law and order, basically. So in the case of the curfew here in Minneapolis, for example, it restricted people from leaving their homes after 8 p.m. until 6 a.m. the next morning. The ACLU recently sued public officials in Los Angeles for a curfew that they enacted early this summer, and part of the argument that the ACLU made in that lawsuit was on First Amendment grounds. So that gives us a pretty solid blueprint into what First Amendment arguments you might have against a curfew. Similarly, LA's curfew restricted people from leaving their homes between a certain hour of the night until a certain hour of the morning. However, in LA, the curfew started at 6 p.m. In the lawsuit, the ACLU argued that this 6 p.m. timing of the curfew was an unreasonable time restriction. You'll remember that's one of the elements, that if a government wants to restrict speech, it has to be a reasonable time, place, and manner restriction. Basically, the ACLU is arguing that this is an unreasonable time restriction because 6 p.m. is very early. People are still at work or coming home from work. Businesses can't be expected to shut down at, 4 or 5 o'clock in the afternoon. The ACLU argued also that this curfew left open no other channels of communication for protesters because it banned everyone from going out into the streets, which was basically what all curfews do, but the ACLU is arguing that this was an overbroad restriction on First Amendment rights because the type of communication at issue, that is protesting in the streets, is literally only achieved by being able to go out into the streets and protest. So a curfew is unnecessarily overbroad and bans that type of free speech, and there is no alternative means of communicating in that way. The ACLU also argued that it was not narrowly tailored enough to achieve the governmental purpose at issue, which was to curb looting and rioting. In the lawsuit, they state that defendants' curfews fail the narrow tailoring test not only because of their extraordinary geographic scope, but also because the lockdown they order restricts far more speech than necessary to achieve their aim. And now, under the parameters set forth in that US v. Grace SCOTUS case that I mentioned earlier, these seem to be solid arguments that the ACLU is presenting, and I wouldn't doubt that an ACLU attorney would be skilled enough to know kind of what the best First Amendment arguments are when it comes to curfews. However, this LA curfew, aside from the fact that it started at 6 p.m., which does seem pretty out of the ordinary, is otherwise pretty typical for a curfew. It bans everyone from going outside. That's kind of what a curfew is. And courts across the country are pretty split on whether or not they are actually constitutional, and again, the Supreme Court hasn't made a definitive ruling on it, so we don't really know. This ACLU lawsuit against LA was dropped because after they submitted the lawsuit, LA lifted the curfew the very next day. So sometimes you don't need to win a lawsuit in order for it to be effective. However, that also means then that we don't really get a clear ruling or a clear opportunity for this case to go up to the Supreme Court to give the Supreme Court another opportunity to clarify what is a constitutional curfew. However, I don't really know if I want this Supreme Court making that decision at this point. Most litigation at the state level has been over juvenile curfews. That tends to be a more common type of curfew. It's not used to quell unrest in the midst of protests. It's instead used as a more permanent measure to try and quell gang violence or other crimes that youth commit in the night. Courts have ruled that in order for those juvenile curfews to be constitutional, they have to have a First Amendment exception to them, meaning that juveniles can leave the home and break curfew if it is for a protected First Amendment activity, such as meeting in various types of groups or going to church, for example. However, these again are for juvenile curfews and not for curfews that quell unrest. So it's unclear whether there would need to be a First Amendment exception to a curfew. And having a First Amendment exception to a curfew that's meant to quell the unrest from protests would be counterproductive, because the whole point of a curfew is to get people off the streets, but one of your protected rights, supposedly under the First Amendment, is the ability to go out and protest. So the curfew would basically have to say that you have to stay inside unless you're going to protest, but if you're going to protest with the intent of lighting things on fire, that's not protected under the First Amendment. You should stay home. You can see how that probably wouldn't work too well. Another right that the ACLU mentions in their suit against Los Angeles is the constitutional right to free movement. They say that defendants' curfews violate the Constitution's protection for the freedom of movement. Citizens have a fundamental right of free movement, historically part of the amenities of life as we have known them. In all the states from the beginning down to the adoption of the Articles of Confederation, the citizens thereof possess the fundamental right inherent in citizens of all free governments peacefully to dwell within the limits of their respective states, to move at will from place to place therein, and to have free ingress thereto and egress therefrom. While the state may impose restrictions on this right, any restrictions must both serve a compelling state interest and be narrowly tailored to accomplish that objective. So again, here they're making the argument that this restriction on free movement, which is supposedly a right that we enjoy under the Constitution, is overly broad and not narrowly tailored to achieve this governmental interest. So for emergency curfews, a lot of times the state that is creating these curfews cites their own police power as a reason for why they are able to enact these curfews. Police powers are one of the reserved powers, which I mentioned in a previous video, that the states enjoy that the federal government cannot infringe upon. Of course, those reserved powers have to be weighed against the Constitution and the Bill of Rights, which does apply to states. Clearly, this lawsuit that the ACLU filed against LA helped because they lifted the curfew the next day. However, as we've seen through this analysis of what constitutes a valid constitutional restriction on First Amendment rights, it seems as though whether or not a curfew is constitutional depends on a number of factors and is not a clear-cut question until the Supreme Court makes a ruling. Despite all these concerns about whether curfews infringe upon people's First Amendment rights, history tells us that they will continue well into the future. So sorry I can't give you a clear-cut answer this time about whether or not curfews are constitutional. However, if you have any questions, please leave them in the comments below. Thank you so much for joining me. Give this video a thumbs up and subscribe if you want to hear more from me. Careful if you're going out on the streets. Power to the people. Have a nice day. Goodbye.